So I stand in support of this bill. Given the rapid development in fintech, we need to ensure our laws and regulation keep up. I have comments and queries on one aspect of the bill and more broadly to requests for an illustration. I refer to the consultation paper MAS shared, dated 3rd August 2017, which listed the objectives of the amendments in this bill. The objectives are to bring Singapore's law on this subject matter up to date with international developments, to enhance Singapore's position as a major financial centre, and to incorporate global best practices from leading jurisdictions like the UK and the European Union. As such, to try and understand the bill, I had a look at the EU Settlements Finality Directive 98/26/EC, which has been since amended by two other directives in 2009 and 2010, and two regulations in 2012 and 2014. The main rule in Article 3.1 is that transfer orders and nettings shall be legally enforceable, even in the event of insolvency, proceedings against a participant, and shall be binding on third parties, provided that transfer orders were entered into the system before the moment of opening of insolvency proceedings. In this bill, I note that Clause 9, which amends Section 8 of the Act, does not prescribe the same degree of certainty as to whether a transfer order or any other transaction in Section 8.1 list will be legally enforceable and binding on third parties as long as a transfer order or any other list of matters entered before an opening of an insolvency proceeding. Can the Minister clarify why this is so? Prescription of this timing is important to my mind, as cross-border payment settlement and netting seems especially vulnerable to insolvency laws in different jurisdictions. I understand that this insolvency carve-out is dealt with in Clause 9 of the bill, which amends Section 8 of the Act. Section 8 of the Act states that transfer orders and transactions in Section 8.1 lists, quote, shall not be regarded as to any extent invalid on the grounds of inconsistency with the law for distribution of the assets of persons on bankruptcy or winding up, or on the appointment of the receiver, receiver and manager, or equivalent officer, end of quote. I appreciate that this has an implied effect of ensuring transactions made through the designated system of DS are final, irrevocable, and cannot be reversed or challenged by insolvency laws or a liquidator. MAS consultation paper also states in paragraph 2.2 that proposed amendments is consistent with laws of the European Union. However, neither does the bill expressly address the timing issue stated in Article 3.1 of the EU Directive on whether such transactions have to be entered into before the commencement of insolvency event, nor address what happens if transactions are entered into the system after the commencement of an insolvency event, regardless of whether a DS or actual or constructive knowledge of the commencement of insolvency event. In fact, Clause 12 of the bill, which amends Section 12 of the Act, makes it clear that the DS operator may effect netting of all obligations owed to or by the participant up to and including 1 business day after. Can the Minister clarify if it is the intention of the Ministry to not draw a distinction and provide a blanket prioritization and finality of transfer order and transactions in Section 8.1 of the Act? If so, can Minister provide further clarifications if this may be open to abuse in any way, such as by a company disposing its assets even after commencing of winding up, contravening Section 259 of the Companies Act by effecting transfer orders into DS? Additionally, can the Minister provide specific examples for members and the public to understand the practical implications of these amendments, specifically the extension of insolvency protection for transfers orders, netting, and settlements in a DS amendment? For example, what transactions would not have previously fall under the Act, which will now fall under the revised Act once the bill is passed? I appreciate that this is a highly technical bill, but it is precisely such bills that require illustrations and explanations. Alternatively, will MAS be publishing guidelines to help the affected parties, such as the DS operators, settlement institutions, financial institutions, and the public, better understand the revised Act? So, notwithstanding the above queries, I stand in support of the bill.